Good morning. It is a great pleasure for me this morning just to have Salome van Wyk, who is the Director of Conveyancing at Miller's Attorneys, with me. And we're just going to talk about specifically around dealing with rental agreements at this time. Morning, Salome. How are you?
Good morning. I'm very well. I hope you're well too.
Yes, no, thanks. We're all doing well. And Salome and I had a brief discussion previously about how does it feel like working at home, and it's really great. And some adaptation to get back to office, Salome?
Yes, it's going to be difficult to have a normal office day, whereas now I can start a little bit later, work a little bit later, and do whatever, and stay in my pajamas all day if I want
to. Well, thank you for not having your pajamas on right now. I'm not sure if it's below that, but Salome, on a more serious note now, in terms of rental agreements and the impact of the lockdown, there's just two questions we'd like to briefly just ask you to share some insights with us. And we do know that you've written a short document which is available, and that people can contact you, but they can also contact their own attorneys or advisors in terms of this, should they need more information. So the first question we just like to just pose around dealing with rental agreements was, we hear a lot about force majeure, and in the context of the rental agreements, specifically in lockdown, what is the process and what does this mean for us as people who rent or landlords?
The term force majeure, another way of looking at it or calling it is an act of God. And in some contracts you would find that wording, and it means it's something from the outside that we've got no control over. Often people would think that we are in quarantine, we can't run our business, it's closed down, so it's impossible for us to make payment of our rental and lease amount. You know, the lease agreement is there, but we can't pay it. Now, first of all, I think it's very important to know that we are in a country where agreements are actually of much importance, and it is something that's valid, and if it's valid, then we must abide by it. If we want to say that there's something that happened that we've got no control over, we could take something like, I've got a business on my own and a sole proprietor, and I get cancer, I can't work, my business doesn't have any income. It's almost the same kind of thing that happens. So can I now say I'm not going to pay my rental because of this? And I think that would be making it a subjective reason for not paying it. So when force majeure comes into play, it must be because of an objective reason that you're not able to pay. Now, it's not 100% clear, because there may be circumstances where you can say, or we could argue, that this is objectively seen as something from the outside. But I think reasonably, you are supposed to be able to pay your debts and everything, and you can't just rely on your income to do that. You have to enter into agreement with the possibility that something can happen, and that you must be able to abide by it. But the other side of that coin is that it is not tested at this stage. There's no court case that I could find that specifically refers to a rental agreement on the basis of this. And then force majeure is often put in an agreement. So it would be a clause in agreement saying that you will still pay, or you will still be responsible despite force majeure. Or it can go to the other side, where it has explanations as to what will happen in the case of a force majeure. And this often you find in agreements where people are do transporting business or that kind of thing, where often roads would close down and they can't deliver in time. you know, so they can't get to the place in time. So they would often put that in the delivery agreement, saying, if something like that happened, we will not be responsible, or that they're not able to get hold of the stuff that they normally sell, and say, okay, you must only buy from me. That's our agreement. Okay, you're not allowed to buy anything from my competitors. But in the case of a force majeure, I will give consent that you can buy from them because I don't have the product. But in rental agreements, in your normal rental agreement, you would not find any clause. And I'm talking about, maybe you will. There are some that has it in, and I've also looked at a few agreements that we have where they specifically talk about floods and things that destroy the building, where the landlord from his side is saying, I can't give you occupation any longer, and therefore I'm not, you know, responsible, and the agreement is cancelled because of that reason, because I can't give you occupation anymore. So one could turn it around and say, but if the wording allows it, depending on what the wording is in the contract, that you would be entitled to say, but you can't give me occupation, and therefore I can't pay, and because of that reason. But it will all be a matter of looking at the specific agreement and deciding on the specific circumstances as to how you can, whether you can enforce it or not. On general basis, I would, as a general things, just say, don't go that way too easily, because you don't want to be in litigation in time that you can't even pay your rental. But the other side of that coin is also that there are landlords, and we are in a position where you can approach a landlord and speak to them and try and get to some sort of an agreement. And I have been involved in this period with a few of my clients from both sides, some of them landlords, some of them tenants, and we've mostly agreed for a payment holiday. So we would say, okay, we are not able to pay now because we didn't have any income in April. You don't have to pay for April. You don't have to pay in the beginning of May, which is coming up. But from July, for instance, you must start paying that back in installments. And okay, we can agree now as well, maybe don't pay for June either, or pay 50% of June only once we get going, if your business is one of those that's able to trade now. But there's a lot of businesses that's still not going to be able to trade. So it will be a matter of agreement. And on the other hand, and I think that gets to your second question. So let's go to the second question, and then maybe we can come back to what I've said in the first one. I think what you say there is not totally correct. The Consumer Protection Act is not applicable to consumers who are legal persons and whose business turnover is less than 2 million, or their assets are less than 2 million. So you could have a smaller turnover but bigger assets, so you would still fall out of. Then it's not applicable to you. Now, normally that would be an advantage for a supplier. If I am a supplier in terms of the Consumer Protection Act, this is a landlord, and I lease my property to the tenant, and the tenant is a CC, for instance, and they don't have a turnover, or their turnover is less than 2 million, or their assets is less than 2 million, then the Act would not cover them. No, other way around. If it's more than 2 million and more than 2 million assets, they would fall outside the Act. But if it's under that, they would fall in the Act. Okay. But there is also a specific clause in the Consumer Protection Act, section 14, that relates to fixed term agreements. And a lease agreement is a fixed term agreement. Okay. So that clause, or that section specifically, says that it is not applicable to, it's only applicable to natural persons. It's not applicable to legal persons. So that section has a clause in it that says that you can give notice, a 20-day notice for cancellation of any lease agreement. On conditions that you must, there can be conditions in the agreement or just in general, which says that you must pay some penalty, some sort of penalty. Often the specific industry would cover what penalty is to be paid. So in the case of the rental industry, a monthly notice would normally be the rental so that the landlord can get a new tenant. Yeah. Sometimes one would say we in a business industry, it's a bit difficult, so maybe 2 months notice would be more applicable. But penalty for 2 months, but you can give 20 days notice. It's 20 business days, so that's also you know, a month. But that is just in the case of natural persons. So often businesses are run by CCs or small companies, which is PTY limited. So it will not help your normal tenant, and the landlord would still be able to get a penalty payment as well. But I think going back is the most important thing, is that there should be communication in these days. One should communicate, go and see an attorney, help you negotiate if you're not able to, if you've got a difficult landlord or a difficult tenant, because on both sides there are things that you have to you know, pay. As landlord, you've got certain liabilities, and as tenant you've got liabilities. So it's not an easy time.
So let me thank you very much for that, and you've given us good clarity, and as you've indicated, really the bottom line is make contact with the landlord, and maybe from the landlord make contact with the tenants as well, as to start saying, you know, what is your position in terms of payment, so that communication can start taking place. So thank you for that, Salome. I'd just like to share with our members as well, and to others watching this, is that we had, as a chamber, submitted a submission in terms of for level 4, what businesses, you know, can open, not open. So we submitted that in time, both to the government as well as the Western Cape province, and other bodies such as Sakaliga and Saki and Busa, with our inputs, and we are waiting to see what will come from that as well. So thank you very much for joining us again, and we're looking forward to having our next discussion. Thank you, Salome, and keep well there at home.
Keep well as well. Good luck to everybody that's at home, and businesses that wants to open. That if we abide by the regulations of the government, it will happen sooner than later.
Thank you very much, and good day again.